our final briefing for today. It will expound the case of Galina Shepeleva and Rodovit ban and the decision by Pechersk Court Judge Lytvynova to close the case. We will speak about that with Dmytro Karp from Civic movement of Ukraine and Anatoliy Bashlovka from the same movement. Please welcome. Good afternoon. We'd like to bring to highlight the situations and developments in our country today around the Shepeleva case, as well as to expound on certain recent developments related specifically to the arrest of Aidar battalion members and the Zaporizhia case with the guys sitting incarcerated for almost 2 months under false conviction. But we'll start with Shepeleva case. We were really surprised by the verdict taken by Judge Lytvynova. You know about the sheer shape of the case and volume of the case. To briefly remind you, some $3 million were taken out of Rodovit Bank, of its assets. They were actually stolen from bank depositors. We have many years long case again of Shepelev, who fled the country. By the way, he was put to a hospital at some phase, and there were hosts of doctors who described the fatal diagnosis he might have had. But then when the General Prosecutor's Office ordered an official medical examination of Mr. Shepeleva, it was discovered that the diagnoses were really false. But he did manage to flee the country. The hospital and the country, together with his bodyguards. It was a collusion. And then the case of Shepelev developed as it went. One of the convicts was his wife. And at some time, the case of his wife was severed from the main case of Rodovit Bank because the court decided they were authorized, in opinion of the General Prosecution's Office. It is standard attempt to just break the case. And in this case of Ms. Shepeleva, Judge Lytvynova really devised a know-how in jurisprudence by closing the case altogether. I think Anatoliy Bashlovka will have more on that. Good afternoon. With Dmytro already describing the core information, I will come to the verdict itself. So Ms. Lytvynova granted the appeal of the defense side to close the case opened by the GPO. The idiocy of the situation is in the fact that the judge herself tasked the GPO to launch certain investigative actions. I'm not a great fan of the GPO myself, but this is just legally ridiculous for a judge to do so. Moreover, she stated lots of evidence purportedly in the case in favor of innocence of Ms. Lytvynova. This is really an idiotic situation because it says effectively we don't need neither the police nor the prosecution side, because the judge is totally free to absolve a person on a pre-trial phase. And what's the most interesting is that the judge deemed her own decision as final and binding. Now I'd like to give the floor back to Dmitry. Actually, it all is about this odious Pechersk court. We had two unique decisions taken by the court, one by Judge Volkova It was and in the case of Lytvynova, we tried to come to a decision with the GPO on how to proceed. We actually entered the GPO office with not good intentions. We tried to convince them that, well, if you release Lytvynova, you will have tires burning in front of your house very soon. Then we came up with a way of proceeding further. We wrote a claim against Lytvynova to open a criminal investigation, criminal procedures against her. At the very least, we have the information about this appeal already entered into the General Register of Judicial and Criminal Procedures. We also addressed the Supreme Justice Council to rule in the case of unlawful actions of the Judge Lytvynova, so that on the very next day of our address to the Supreme Justice Council, it ruled about the illegitimacy of this decision in the case. I would really like to ask the President whether it is expedient now to really dismantle the Pechersk court, because it serves not its stated purpose. So actually, it is about the building located in Rilskova Lane 4, which costs $10 million at least, and which has been taken by Yura Yanakivsky. Then there is information about at least $30 or $40 million, as we were informed by the Swiss prosecutor's office. The Swiss authorities do not want to release this money back to Ukraine, and we were explained by them that these money are under criminal investigation. These are the money of bank depositors, and we were asked by them to provide the Swiss side with more documentary evidence to rule in the case. But actually, since April, when this information was passed to the Ukrainian side, the GPO hasn't done anything, and there is no progress in the case, with depositors swarming under the National Bank of Ukraine, demanding their money back. And similar situations we have in many other banks in Ukraine, by the way. So our idea is to really join our efforts all over Ukraine to launch some lustration efforts against unlawful decisions, judicial decisions, and unscrupulous judges in absence of other measures of redress. We have no other option than to personally oversee and control every verdict in cases we have here in the country.
I would like to tell you the story about Brigade 51. Now, we have been dealing with this case for several months already. Several days ago, we visited Zaporizhia, and I would like to remind you that Brigade 51, this is the military detachment which during the military campaign, they got into Russian territory during encircling, and then they came back to Ukraine, and now they are incriminated with the illegal flee from the battlefield. We met with the Prosecutor General of the Zaporizhia Oblast, and Prosecutor General who met with us promised that they will face the
повноважень і надалі.
the sentence verdict, and but actually those guys are not imprisoned, are not arrested, but actually they are arrested. They stayed on the location of military unit in Zaporizhzhia Oblast. We are not happy with the actions and deeds done by Prosecutor General, and we will appeal to the Court of High Instance. Brigade 51 suffered very much, and when we were in the courtroom during the court session, and we saw how Prosecutor General requested that those guys should be condemned, and when those guys said that we had no other way out than to escape to Russian territory because of heavy fire, the Prosecutor General advised them to be killed and to be slain, actually, on that very location where they had no support from other troops. And actually, the criminal code provides that the judge can prescribe to a person and prevent the person from going somewhere. But actually, these guys now stay arrested in the military unit in Zaporizhzhia. And actually, they do nothing in the location of that military unit. Thus, for several months, those people are oppressed, despite the fact that they hardly managed to survive during combat in the hostility area. Unfortunately, the criminal code provides that the verdict could not be appealed, and when we tried to investigate whether there was a military order for them to stay in that very place, we found out that there were no order for that unit to stay there. And unfortunately, this information is closed. As of the moment, we understand that people were in some location. When they were heavily attacked, they tried to escape, and now those people are blamed that they escaped without permission from the commander, and this is nonsense, actually. And the most recent story, some days ago, some Aidar battalion soldiers were arrested when they were escorting Mr. Malyshev, and during this convoy, wife of Mr. Malyshev wrote a letter, request that he was kidnapped, and requested his return. And in line with that request, we had to counteract to what was done, and the Pechersk court has made a decision, but under pressure of broad public, and Aidar soldiers were released, but without a permit to leave their place of residence. Malyshev was deputy head of Lugansk state administration on healthcare issues. He was appointed during Yanukovych times, and despite the fact that he resigned several weeks ago, but he actually stayed in his position, and also he later became the Minister of Healthcare in LNR, and we have quite sufficient evidences and proofs about this fact. His son currently works for the security service of Ukraine. He has a lot of relative relations with the prosecutor's office in Ukraine. So about this kidnapping, he was not kidnapped. Actually, he did not oppose to those who suggested him to accompany him to Kyiv. Also, he was free to use his cell phone. He promised to provide them with the documents supporting the blame of Yefremov and to show that Yefremov funded separatism activities, and together they came to home of Mr. Malyshev, where they were detained by Ukrainian law enforcement agencies. Where is Mr. Malyshev now? We do not know where he is now. We negotiated a long time with the security service of Ukraine, and for us it remained unclear whether they filed the case and started investigation about him or not. We have a lot of evidences from Lugansk residents that he is guilty, and for us it's quite obvious that it was ordered by somebody or prescribed by somebody to stop this case. The case about Mr. Matthews, he is a brother of Maria Matthews, but he is rather far from cultural issues, unlike his sister, who is famous Ukrainian writer. Beginning with the times of Yuri, of President Yushchenko's times, and till President Yanukovych times. Actually, he worked as a deputy of Mr. Levachkin, and his main task was to circle around the oblasts of Ukraine and to force people do something which was prescribed by central authorities under Yanukovych regime. And without this contact with IDAR, we would never guess that there is again a wrong appointment in the Prosecutor General office.
Coming to IDAR case, I'd like to tell you that we are coming back to the times of Yanukovych, when we come to temporary detention facility just to be fooled, when we try to close the door to prevent them from carrying the guys away, and we just force the policemen to disclose that the persons they say is not there really sits there. When we are being told about, say, let's make a video conference tonight, in the night, in spite of us requesting an open discussion. It's like some absurd theater. It really gets funny at times because it's like people living their final days and if we check how people are detained, if we check how evidence is collected, how witnesses are dealt with, we may see that exceptionally low level of professionalism in GPO. When an undisclosed individual calls a witness to express what he or she had saw or heard, and the witness himself says he may not disclose the name of the person, and this false or at least faulty information is played in the basis of the case, I was really surprised when I saw that level of professionalism in the GPO. Surely, with that solemn decision taken by the judge in Aydar case, I would say that, well, we should think about where to find the money the guys should put on bail to be released on bail. It's about 24,000 hryvnias each. But again, every time we hear that the person is doing everything on a free will basis, and again, the information from Ministry of Internal Affairs spokesman Mr. Herashenko that Mr. Malish was drunk as hell by the time he was escorted to Kyiv. And we knew that he went normally, not under any influence, with Aydar fighters. That is, and the way the guys were received at Malish's place, we may see that everything was well prepared in advance. It was a kind of performance, pre-rehearsed already. Speaking of Mr. Matios, you can check available video materials. It is really a sheer lack of professionalism, an inability to communicate. Is this the true and proper level for military prosecutor to work? If we take Aydar, if we take 92nd, 85th, 52nd brigades, we will see that the GPO does whatever it can to really bring the whole of the guilt on them, rather than seeing the real guilty ones among the top brass. Thank you. Any questions? Could you tell us why it was necessary to bring that odious personality as Mr. Malish from the area of military action to here? Would it not be better to arrange for that transfer elsewhere, to a local security office, for example? It was pre-agreed with the State Security Service, and I will explain why. Because the lower level, the lower level of security services can be used for that. But many times we were told the people are released from local State Security Service offices really the very next day. That was why it was decided that the guys will bring Mr. Malish here to the central office. If no further questions from my colleagues, may I ask Dmytro the question about the law on lustration and the last draft of this law? Are there any provisions that concern judges? Again, that's an odious topic in itself. Now about lustration and the relevant piece of legislation. This is the legislation that the president should not be signed by the president. The president should not sign at all cost. If he signs it, we will get a very solid tool to just raise cases against anyone at will. So actually, speaking of lustration itself, the head of the authority has to supply lustration lists. That is, it is about the top manager to decide, not for the people to decide who needs to undergo lustration. While according to normal legislative procedures and structures, it should be an independent procedure. Well, but they say that the Ministry of Justice is also subject to lustration. Well, let me ask you a question. What will happen to Mr. Petrenko, who has done a lot of harm and who is really unlikely to go any lustration? I'd like to really tell to Mr. Petrenko, to Mr. Sobolev, to many others, don't be in a haste. Don't indulge into this PR campaign. Think before signing and doing. But what is your proposal then? Say to arrange lustration among those judges that are known for these illegal decisions you've described. First of all, let me tell you that lustration is the baseline principle. It's a uniform principle. So it is really a strange case when a state, a governmental authority, launches lustration. In that way, we are getting only a tool to streamline the lines of bureaucrats in their own interests. Lustration should be done to a strict principle against specific groups of people. Otherwise, it will be a criminal offense. And it should not be the same. A criminal offense and lustration should not be the same. We need to decide among us in the society those categories of people who may not assume governmental positions for certain specific reasons. Surely there are still risks that some innocent people may become victims of that lustration, but this is again for the society to go further in its desire of lustration and to rectify possible mistakes. In this case, with this legislation, it will be very hard to explain to the people that it will be necessary to lustrate the lustrators themselves. There will be commissions, lustration commission, there will be lustration committees, and there will be even more corruption that we'll have to tackle.
Well, somebody has to do it physically. Yes, there is a principle, and any person knowing that something is going on may step in and say this or that nominant was involved into this or that activities, and that could be changed. There was the bill number 4570, which suggested to establish anti-corruption bureau, which provided for the court of judges, and thus each person could be illustrated via court proceedings. Today, actually, we allow people to become ministers, to work for a month, to pay a bribe to those who will lustrate them and allow them to earn millions of hryvnia. This is actually the mechanism which will allow people to continue with corruption. Thank you. Our briefings for today are all.
Кваліфікують її дії. Яка стаття там?